Hello and welcome to the Glad Possible YouTube channel. It is only sometimes in your life that you get the privilege of talking about a personality who's not just impacted a certain individual or a couple of individuals, but the entire country. Yes, I'm talking about the sad demise of advocate Nariman. And today, let's go on a journey and let's understand what this person has contributed to the legal landscape of our nation. And you, as CLAT aspirants and ALET aspirants, need to learn from such examples, need to look up to such people so as to be able to, make your own contributions to our country. Now, the very first one being the Golaknath case. I'm not getting into the intricacies because I know that you haven't gone to a law school yet. But let's try to understand what this is, and more than that, the significance of this judgment on our lives. So the backdrop is that जो सरकार है इस टाइम पे उसकी प्राइम मिनिस्टर है Indira Gandhi. Now, Indira Gandhi at that time was not getting a lot of support from her own party members. Reason being, they thought that, she's become a prime minister just because of her name, and she's actually, there's nothing more to her. She obviously wanted to be much, much more than that. And she was planning in her head that, listen, I'm going to conduct elections again and I'm going to come back with a huge majority, which she did. But right now, her party members were not supporting her. So she really, really needed the support of public. So she realized there is this one way of getting that kind of support. And what is that one way? Take from a few, distribute it amongst the rest. Of course, there was the bank nationalization case and the privy purse case, but we are not getting into that. Today, we are talking about the Golaknath case. So you have to understand 1967 मतलब right to property अभी भी मेरा fundamental right है. तो इंदिरा गांधी की सरकार ने बोला यार ये जो कुछ लोग हैं ना जिनके पास बहुत ज्यादा जमीन है इनसे लो और बाकियों में बांटो, भला हो जाएगा बाकियों का. अब बेटा ऐसे टाइम पे somebody you would have come to you and said oh please भला कर दो बाकियों का, अपनी प्रॉपर्टी बाकियों में बांट दो, तुम चुप करके दे तो नहीं दोगे. इनफैक्ट ये तो तुम्हारा मूल अधिकार था. This was your fundamental right. You would have gone directly to the Supreme Court or the High Court, and that's exactly what people did. Advocate Nariman was on behalf of the petitioners and he argued the same, and that is what the judgment was. कि देखो भाई पार्लियामेंट को बोल दो कि ऐसा कोई लॉ ना बनाए कि लोगों का फंडामेंटल राइट छीन जाए. वो इक्विटेबल डिस्ट्रीब्यूशन ऑफ मटेरियल रिसोर्सेज के कारण हो या प्रिवेंशन ऑफ कॉन्सेंट्रेशन ऑफ वेल्थ के कारण हो, मतलब आपकी इंटेंशन अच्छी है बट वी डोंट वर्क ऑन इंटेंशन, वी वर्क ऑन द लेटर ऑफ द लॉ. And the letter of the law says that right to property is a fundamental right in 1967. Till the time that is true, you cannot take such an action. So that was the first contribution that I'd like to talk about. The next one. Now, the implication of these decisions were huge. Now, what were the implications? This is what has made sure that independence of the judiciary is maintained in my country. See, we keep reading about the appointment of the judiciary, and of course, Supreme Court, High Court के judges कौन appoint करता है? President. But wait, hold on. I live in a country wherein whatever the president does has to be according to the aid and advice of the Prime Minister and the Council of Ministers. But then if that happens, then where is the independence of the judiciary? Now, I'm not saying that, the Prime Minister and the Council of Ministers are bad people and they would not like to, they would like to sabotage the judiciary. I'm just saying they're human beings. And so if you and I are also there, we would also like favorable judgments. That's just how a human being is. And so hence that had to be avoided because of course that's like the third pillar of our democracy, right? And so, went on these cases called the first judge's case and the second judge's case, the third judge's case, in fact, the fourth judge's case. पहले वाले में तो बोल दिया कि अच्छा ठीक है, प्रेसिडेंट जब अपॉइंट करेगा सुप्रीम कोर्ट के जजेस को, जजेस से पूछ लेगा, मानने की जरूरत नहीं है. फिर से वही बात हो गई भाई, तो साइड में रखो. सेकंड जजेस केस आया. सेकंड जजेस केस की बात करें तो उसमें बोला चलो ठीक है, नहीं, द प्रेसिडेंट शुड टेक द कंसेंट ऑफ द जजेस. कितने जजेस? 2+1. One is the CJI, 2 senior most judges. चलो ठीक है, that also makes sense. Consent लेना पड़ेगा. अब independence maintain होगी because the executive is not interfering in the judiciary. But wait, hold on. What if the Chief Justice of India says Priyanka को Supreme Court का judge बनाओ? And these 2 senior most judges says Mr. X को Supreme Court का judge बनाओ. अब प्रियंका को बनाओगे तो बाकी 2 बेचारे क्यों बैठे हैं? और Mr. X को बनाओगे तो ये इसको चीफ ही क्यों बोल रहे हो? So then it had to be, interpreted again, called the third judge's case. फिर यहाँ पे इन्होंने बोल दिया नहीं 4+1 judges, जहाँ पे CJI की बात पक्का माननी पड़ेगी. ये सारी की सारी चीज़ों में बहुत बड़ा कंट्रीब्यूशन था एडवोकेट नारिमन का. Now, I'm not asking you to just get into the technical, the technicalities of it. Of course, you need to know that. But you need to also understand that this ensured the independence of the judiciary. I mean, 100% surety kabhi bhi nahi hoti, but to a maximum degree, right? That was the contribution of this man. Of course, later on, the government came up with the 99th Constitutional Amendment Act. And 99th Constitutional Amendment Act से गवर्नमेंट ने बोला नहीं, एनजैक बनाते हैं, नेशनल जुडिशियल अपॉइंटमेंट कमीशन. एग्जीक्यूटिव का फिर से रोल इंक्रीज कर दिया, सुप्रीम कोर्ट ने फिर से मना कर दिया. एंड ऑल ऑफ दिस इज द रीजन व्हाई जजमेंट सच एज और डायरेक्शन सच एज the one that the current Chief Justice of India has made with respect to the Chandigarh mayor elections can actually take place. And that's the beauty of this man, right? Let's go ahead. The next one is to do with minority educations. अब पता नहीं आप न्यूज़पेपर पढ़ रहे हैं कि नहीं, पर अलीगढ़ मुस्लिम यूनिवर्सिटी के ऊपर बार बार ये लांछन लग रहा है कि तुम माइनॉरिटी एजुकेशनल इंस्टीट्यूशन नहीं हो, तुम बाकी लोगों को SC ST OBC को रिजर्वेशन दो. जबकि आर्टिकल 30 of the Constitution says that a minority has the right to establish and maintain their own educational institution. Yeah? And also maintain का मतलब ये है कि कितना परसेंटेज रिजर्वेशन देना है, वो मतलब मैक्सिमम इज 50% पर दे सकते हो, पर माइनॉरिटीज को. यहाँ पे TMA पाई फाउंडेशन वर्सेस स्टेट ऑफ कर्नाटका में द कंटेंशन दैट वाज पुट फोर्थ एंड एक्सेप्टेड put forth by advocate Nariman and accepted by the judiciary was that minority केवल country wise नहीं, state wise भी आपको determine करनी पड़ेगी, right? Because some linguist, कुछ एक religion can be a minority here, might not be a minority here. कुछ एक language speaking linguistic group can be a minority here, cannot be maybe a minority there. And that was what this man did for the minorities in our country. Let's go on to the next one. Nabam Rabia versus Bamam Felix versus Deputy Speaker. अब ये समझने से पहले मैं आपको एक चीज बताऊं. That there are two articles in the Constitution. One is Article 74 of the Constitution. One is Article 163. Article 74 बकायदा बोलता है that the President shall listen to the aid and advice of the Council of Ministers and the Prime Minister. कोई शक ही नहीं है. But if we talk about Article 163, ये कहता है that the governor will consult माने सुनना है सुने, ना सुनना है ना सुने. But Advocate Nariman's contribution is this, that today the Supreme Court has said that the governor has to abide by the aid and advice of the Chief Minister and the Council of Ministers. And guys, that is because of the fact that this is not a presidential form of democracy. This is a parliamentary form of democracy. तो एक विधान सभा को बुलाने से पहले गवर्नर को Chief Minister, Council of Ministers की aid and advice माननी पड़ेगी. The next one is Union Carbide Corporation versus Union of India. And a lot of people have a problem with it. How can he stand, from Union Carbide Corporation's side? Oh my God, he was such a bad guy. Listen, there's this article in the Constitution called Article 22 that also gives the right to, approach a legal practitioner. This is a fundamental right which is also given to the accused. So you can't take that away. That is also a fundamental right given by our Constitution, right? So yes, that was another case for which he is very, very well known. And for all of these reasons, he was given the honor of a Padma Bhushan in 1991, Padma Vibhushan in 2007, and the Grubber Prize for Justice. Well, this is not the only contribution that the man has made. But of course, this is some of what he has done for our country and for our legal landscape. If you found this video informative, kindly like our channel and we will keep coming back with such videos. Thank you.